Hi, everyone. Thanks so much for joining and tuning in. This is Camille Sams, your Zen lender. And with me again is Erica Carter Walden with Pacific Playa Realty. And this is the first part of a two-part segment where we will be talking more, dive deeper into the probate process and really describe what happens during the probate process. So this is Erica's expertise. Actually, when we do the recording, you're on that side, so I'm going to do it this way. And so, please, Erica, enlighten us. What happens?
A lot happens.
Right.
So this is gonna, as Camille said, this is gonna be a two-parter, and the majority of what I'm gonna talk about today happens before you even engage with me as a realtor. So there's a lot that happens before we get together. We're together for whatever time it takes to sell the real estate, and then a lot happens after that. So, and then the other thing is that people don't realize that the money from the sale goes into an estate account and you don't get to touch it until the court says you can touch it. So it's very important that you know all the things that happen after you sell the real estate so that you can actually get to payment sooner rather than later. So what I'll do a little bit of recap. We discussed in the last video that probate begins obviously when someone passes away. And in addition to notifying people that they passed away, calling and making, preparing the services of remembrance, if they died with any assets that accumulate or amount to $166,250. I know it's a random number, but that is the number. And they died either with a will only, no trust, if they died with a will, or they died with no testamentary plan, no written anything about what you want to be done, then you must file a petition for probate. So they may have a house, you may call me, oh, my uncle passed away, we just had the funeral, we're ready to sell the house. I will ask you immediately, is there a trust? Are you the trustee? If not, we need to go to probate court because the house is likely going to be worth more than $166,250. So in the last video, we discussed who could file the petition for probate and when. There's a priority of appointment. So please refer back to that video for the discussion, or you can reach out to me if you've seen it and you still have questions. So in this video and in the next video, we'll cover an overview of the probate process. There's just so many moving parts to it that we're just going to hit the highlights. And again, there's a lot that happens before we even have our conversation about selling the real estate. So this video will take you through the filing of the probate up to hiring an agent, hopefully me, to sell the property. And then the next video will pick up with a discussion about after we agree to work together, what it looks like to work together to sell a probate property, and then what happens after the property is sold, and then ultimately when you can actually recoup the money or distribute the money from the sale of the assets.
Yeah.
So yes, there's a lot.
And I'll just kind of interject a little bit and say, reiterate what you just said. That's the reason why we're doing this in a two-part process, because I know as you and I have had discussions preparing to put this content together, I remember you telling me once the property is sold, you're still not done. Like there's a whole other level like a whole other phase that you go into. And that really surprised me, I think more than anything, more than what triggers a probate, the whole process, the amount and everything else. For me, having been in this business, so I know a little bit more than the average person, when you told me that was the shocker part of it. So yeah, I'm interested to hear more about it. So please, without further ado.
Yes, so that's the biggest surprise for a lot of people. Is like, okay, when we sell the property, I get my money. No, you have to ask the court for your money, and the court gets to say yay or nay about your money. So it's a whole thing. So we'll talk about that more in the next video. So in this video, we'll talk about, I'm going to start about how we start the process. So as always, my always disclaimer is, please hire an attorney that's actually done probate before. I mean, you can hire a a divorce attorney, you can hire a landlord tenant attorney, but probate is its own thing. So please hire an attorney that has done probate before. Don't let them try it out on you. It doesn't work out that well. If you need a referral, give me a call. I'd be happy to refer you. I have worked with people that have done this themselves successfully, but it's really, really much better if you hire an attorney.
And to that point, excuse me, and to that point, particularly because we do end up in situations where this is family, you know, and we talked about in the first video a lot of the emotional, you know, baggage that comes along with the process. And so I think it's really important that you've just pointed out the importance of making sure the attorney that you hire has done probate, has a specialty in probate, because oftentimes, and we know this even either, you know, through real estate transactions, if you get somebody who doesn't understand how to do, you know, first-time home buyer programs or renovations or whatever, there are these little nuances. So just because your cousin's husband's sister or whoever is an attorney and they mostly do, you know, personal injury, and they're thinking, oh, I remember covering this in law school, it's not the same. And we know so often you get what you pay for in these transactions, and you think you're saving a couple of bucks, you think you're going with somebody who you trust because this is family and you know them and you feel like they're not going to dupe you. They come over every Thanksgiving, whatever, you know, your godchild, your godparent to their kids. But if they don't specialize in this, it's going to cost you more time, more money. You know, there's a lot of these specialty nuances that go into these types of transactions. So I just kind of wanted to add a little bit to that, that it's really important that if you're in a situation that you need to sell a property, you're going through probate, that you really find somebody who specializes in probate.
Yep. In probate sales, which is what I specialize in, and in the probate process of filing the petition and all of that. I mean, there are agents that really know what they're doing in probate, and then there are agents that I've been across a transaction with, and I've had to really kind of educate them on how to handle the process, which makes things go a lot slower and not as smoothly as possible. So having someone who's an expert and this is what they do is really, really key. The other thing I will say is that probate, you'll retain an attorney, but the attorney gets paid at the end of the transaction or at the end of the process like everybody else. So they keep up with their hours that they bill, but you're not getting a monthly statement from them unless there's a litigation with regard to the probate. But just moving through the probate petition and resolution of it, the attorney requests the fees from the court at the end of the transaction. So you shouldn't let that be a deterrent. And again, we can talk offline if you want to call me directly about that, or reach out to a practicing probate attorney. But you know, I wouldn't let that deter me. You actually do need, you know, a professional to help you in this sort of transaction. So if you want to start the process without an attorney, or even if you do start the process with an attorney, the first thing that's done is you file the petition for probate. The attorney has their forms, but if you want to start the process, file the petition, and then find counsel, you would go to the California Judicial Council forms website. All kind of forms are there: divorce, landlord, tenant, probate forms. The website is www.courts, that's courts.ca.gov. And you're going to look for the petition for probate. You'll complete that. Basically, you're saying you're petitioning the court to either yourself be the personal representative or on behalf of someone else. So if Camille was my sister, I could file the petition, pay the filing fee, all of that, and say, I would like Camille to be to administer the estate. So that's perfectly reasonable, but you're filing the petition either for you or for someone else to be the personal representative. You're going to, as a personal representative, you're going to safeguard the decedent's assets, meaning you're going to marshal everything, bring all the money together. and you're going to pay their debts. There will be creditors' claims, all of that need to happen. There's a statutory period that you have to allow creditors, which we'll talk about in the next video. So it's not a quick willy-nilly process. There's actual things that have to take place. And ultimately, the part that everybody thinks about, you're going to distribute the assets either to the heirs or to the beneficiaries. So by being a personal representative for the estate, it really does, as we talked about last time, involve a lot more than selling the real estate. You have a huge job here to do. And for many, it's a thankless job. We talked about last time. There may be family members or other individuals complaining, creating obstacles along the way. It's, it can be daunting. So this is not something that you take on lightly. It is a job, and you have a fiduciary duty to the estate. And they will make you sign a form that makes you know that you have a fiduciary duty to the estate. So when you file your petition, again, just a little bit of review. If the person died with a will, you're requesting to be granted letters testamentary. So you'll check that box on the petition. If they die without a written plan, you'll check the box saying that you're requesting letters of administration. It's on the form. It's just a check box there. If they died with a will, but the person named as executor in the will is no longer with us, they may have passed away, they may be incapacitated for some reason, they may have Alzheimer's, for example, and they can't do the job, they may be incarcerated. It happens. Don't look at me crazy. It does happen. You'll check the box and it says that you're requesting to probate the will with letters of administration with will annexed. So those are your options on your form that you'll be printing out. And again, as a refresher, personal representative for a will, you will be the executor. They will be distributing to beneficiaries. If there's no estate plan, personal representative will be administrator, and they are distributing to heirs. So by this petition, this is still step one, filing the petition, you're going to ask for authority under the Independent Administration of Estates Act. It's abbreviated IAEA. That's all what it stands for. It's just saying that when you're appointed, you can take authority to probate the estate without the court supervising your every single move. The court does supervise the process overall, but it doesn't like ask you every day to check in. So in another video, I'll explain the differences in the authority that you're requesting. You'll either request full IAEA authority or you'll request limited IAEA authority. As a teaser, full authority, particularly during a pandemic, helps us sell the real estate much faster, and it's a much easier transaction. But we'll talk about that. It's a whole thing, so we'll talk about that specifically in another video. But those are your two options. As part of the probate process, you'll also need to pay a bond in most probates. Now, sometimes the court will waive the bond, but generally you, as the administrator, you will need to obtain a surety bond. And the bonds are ordered by the court to protect the estate and its beneficiaries or heirs against loss, theft, or improper activity by the administrator. So I'm going to use somebody else. So say Veronica is the administrator for the estate. Veronica then hires me to sell the property. I sell the property. The money, escrow is directed to put the money into the estate bank account, but somehow Veronica gets the money herself and then flees the country. She is now in the Cayman Islands kicking her feet up. Well, the surety bond will then recoup pay the beneficiaries and or heirs for their loss. They'll compensate them for the loss. That's the word I was looking for, compensate them for their loss. And then they'll go after Veronica and recoup their money from her. But it's there so that the estate doesn't suffer a loss. So that's the whole purpose for the surety bond. That's why it's not waived completely very often. You have to, there has to be some other circumstances to be able to do that.
Now let me ask, is there a cost associated with obtaining that bond?
So yes, you have to fill out a bond application and all of that. That we can talk about that separately offline. I'm just giving you kind of the overview, but yes, you do have a bond an application that you have to fill out. Now that becomes a problem with people with not so wonderful credit.
Mm.
So you have to have a certain amount of credit to be able to be you have to be bondable. And that may deter you from being able to be an administrator.
Oh,
I have seen that where you've had to get a co-signer. Some attorneys will co-sign with you in certain situations, but that's a whole nother discussion. But you
right.
do have to be bondable.
Okay.
You can't have taken money from your employer and have all these cases that you are not very good with money, and you've done some nefarious acts. You have to be bondable. And the court will actually take that into consideration if you are wanting to administer someone's estate, because you are taking care of their money and their finances and their assets. Are you trustworthy? Are you someone that can honor their obligations?
Right. And that makes sense.
Yeah. So if you're petitioning for probate and you have the will, you must attach it to the petition. If you are petitioning to probate a will that's handwritten, there's a whole nother set of rules and things. So consult with an attorney about how to probate or how to prove a handwritten or a holographic will. But either way, if it's a will, it needs to be attached to the petition. You'll then have your cover sheet attached to that, and you'll pay your filing fee, and then you'll submit it to the court.
Okay.
So once the court receives your petition, they'll set a date to hear the petition for probate. It was generally 4 to 6 weeks before COVID. You have to talk to an actual practicing attorney now to see what's happening. I suspect right now, based on the probates sales I'm currently handling and that I'm talking to administrators about and executors about, your hearing date, if you file now, would be next year, because we have holidays and things coming up. So either way, the court will then tell you when your hearing date is. When you get that hearing date, you then need to move to step 3, which is a notice of death publication.
Okay.
You have to file a notice of death publication in the newspaper. The purpose is to provide notice to the world that someone has died. You are petitioning to probate their estate. If they want to make a claim against the state, this is their notification. It must be published again, it must be published in the newspaper. It must run at least 3 times before the hearing date, which you will have received from the court. So on your notice, it says, hear ye, hear ye. John Doe has passed away. Erica Carter Walden is petitioned to probate his estate.
Right.
The hearing on that petition will take place February 15th, 2021. If you got something to say, speak now.
Yeah.
And the first publication must run at least 15 days prior to the hearing date. It's usually run a lot, sooner than that. But that's why they allow that time. But A, the court's calendar is full. And B, you need time to be able to do this publication. And it's usually made in the city where the decedent lived, because that's usually where the property is located.
Okay.
Step 4, we're going to also provide a notice to administer the estate, a petition to administer the estate to the people that actually are related, or heirs, or specifically heirs or beneficiaries. So you can't just do a notice in the newspaper to people like that. You have to say to all the siblings and nieces, or whoever is named in the will, or whoever may inherit by law, I have filed a petition for probate. The court date to hear that petition is here. This is the courtroom. This is the time. You have to let them know specifically that you have filed this petition. And then because you want to give the heirs and beneficiaries an opportunity to appear at the hearing, to express their interest, if they want to, petition, if they want to object. I've had people come in as a lawyer. I've had people come. You've asked your client, okay, everybody's in agreement. Yep, everybody's fine. We go there to court. The judge is, recommending for a review. And here comes cousin Lucy. I object. Okay, are you related to the person? Why do you object? And then the court sets the hearing out for another 45 days to allow everybody to file their, documents to say why this should happen. The other thing that can happen is, as we talked about in the scenario last time, it could be Veronica's dad passed away, but Veronica's dad married somebody else. Veronica files a petition for probate, somebody else, the new wife, has priority over Veronica. So wife number 2 can just stroll into court and say, and they don't have to have filed anything. They can do a verbal objection, and the court will then allow them to file something. Say, I'm the wife, she's the daughter, I have priority, I want to petition for probate. And then the wife will likely win in that scenario. So you have to file this notice, the notice of publication in the newspaper, and you have to file this notice or give this notice, serve this notice on the heirs or beneficiaries. And then for both of those things, you have to then give those documents to the court as proof before the hearing happens that you've given notice to the world, so they have the notice of publication, and that you have noticed all the proper people and they have a proof of service for them.
Wow.
Because the judge will ask you, or the probate attorneys that actually look at the record and prepare it for the judge for their hearing will say, they'll call that out. We don't have any proof that they did these things. So you actually need to submit that back to the court before the hearing so that you can be ready for the hearing date.
Got it. Okay.
So now we finally get to the hearing. We've done all of this and we haven't even been to court yet to get appointed. And we certainly can't call the realtor.
Approximately what's that time frame? And again, this is post-COVID, like from the moment, you know, Aunt Betty dies until it's time to go to, you go to court, again, post-COVID, what was approximately that time frame? We're talking about 45 days, 60 days?
So pre-COVID, it was about 4 to 6 weeks you were being calendared out. Now it's longer. It's right. You file now, you are almost certainly going to be in 2021 before you.
Well, yeah, I'm sure like 3-4 months, roughly.
Yeah. But I've also had, as a lawyer, I've also had people that have passed away in 1970s, like before I was born, and they never got around to filing a probate. People just paid the taxes and the mortgage and kept moving. And so you'll see a record that says date of death, you know, February 13th, 1985, but the petition is filed September 20th, 2020.
My head's exploding right now because I'm thinking about so many, and I don't want to get too far off on a tangent on this, but let's say that situation, somebody died 10 years ago. Okay, let's not go as extreme as, you know.
Oh no, I've had a probate that with the people died before I was born.
I believe you. Yeah. But let's just say 10 years ago, because the span of 10 years at least takes into account if you're paying the property taxes, you've been living, you know, you've established that as your homestead. So let's say it has been 10 years. Does that property does still have to go through probate because the person who's with the sister, the whoever, mom that's been still paying the property taxes all these years, they legally don't own the property, which means legally they can't sell or refinance. They can't leverage the property by any means. So that still triggers probate. Like they can't assume any ownership of the property.
No. Mm-mm. You can't sell what doesn't belong to you, and a dead person can't sell their property. So the whole point is to get the property from the dead person's name into an entity so that the person responsible for that entity, the estate, can then sell the property. It doesn't care. The law doesn't care that Aunt Susie's been living there since before Grandma died. It's still Grandma's property.
Wow, that's good to know, because I get those calls sometimes. You know, I've been living here for so long, but I've been paying the taxes. Doesn't this mean I have ownership of the property? So, okay. All right, I'll leave that alone, because that's like a whole...
That's a whole sidebar, and how the person can maybe
right
some of that money that they benefited the estate. It's a whole sidebar. But no, the property belongs to Grandma. I'm sorry, Aunt Susie. Thank you for keeping the property out of foreclosure.
Exactly.
But yeah, you can't sell what doesn't belong to you, and dead people can't sell real estate. It's just, yeah. There's a lot of rude awakenings in probate. Things don't get buried. They just come to light. Yeah.
Learning.
Like people who aren't really related.
Yeah. My play sister. My
Yeah.
auntie, that's really my mom's, that's I call her my auntie, but really that's my mom's best friend from college. And no, we're not related, but she told me. So anyway, okay,
Yeah.
I'll keep my mouth shut. Go ahead.
Digress. So after all of that, we've actually finally now made it to the hearing. So we
Okay.
are at the hearing, and sorry, I just pressed the button that did something.
That's
crazy.
okay. I'm so glad that you remembered where we were, because I took it all down a whole other road. So anyway, go ahead.
So we're at the hearing, and an heir or beneficiary may challenge the person, we just talked about this, seeking to administer the estate. They can just walk right on up to the court. They haven't filed anything. They don't have an attorney. I don't want my sister to probate the estate because X, Y, and Z. It could just be I don't like her and I want to cause problems. That is not a reason why the court would not let your sister probate the estate. But now we have a challenger. And so if there's a challenger, the court will then set it for hearing and allow that person time to do a written objection, hire counsel, all of these other things. And now the person that filed a petition that was a simple petition now has to have kind of a battle. And so that is not covered under the statutory fees. That is something you still will have to pay your lawyer because they're trying to battle. Once you're appointed as administrator, that's when the statutory fees occur, and they get paid at the end. But until you get appointed, you are coming out of the pocket for money. So if, let's just say nobody objects, which is ideal and usually is what happens. People have had this discussion, okay, you do it and we support you, or you do it because I don't want to do it, or everybody's not it, and it's like, okay, I guess I have to do it. Yeah. So say nobody objects. And you've completed all the requirements with notice, you've answered all the court's questions, you submitted all these forms back to the court correctly. The court will then appoint you as either the administrator or the executor.
Okay. Can I ask a question? Can you have more than one appointee? Like, let's say that there are two siblings, because it is such an arduous job, right? Let's say you've got 4 siblings and everybody is harmonious, everybody is in agreement, but you just say, you know what, the 2 of you really have whatever, you 2 are more capable of taking care of us than the other 2 are. Can you have more than one person?
You can, but I don't like it.
It complicates it. Okay, that's it.
It complicates it, but people do it. I have one right now, and unless so one may be willing and inaccessible, and now you have 2 people that have to sign all of your documents. They have to sign your listing agreement. Okay. They have to sign offers. You have to track these people down. One may not use DocuSign. The other may be fine with DocuSign.
Got it.
Or they just may not like each other that much. And in order to keep peace and keep the process moving, you have both agreed to work together, but you don't really want to work together. So it can create problems, but it happens. I have one right now I'm selling real estate for, and it just, you just have to try. One person signs electronically, the other person doesn't. So you have to just kind of do a little bit more legwork. Okay. But yes, to answer your question, yes, you can have more than one. You can also have more than one trustee in a trust. So you can write your trust, which hopefully you do after seeing all this video about, I don't want to go to probate court and put my people through this. You can have more than, you can have co-trustees also, but it creates the same challenge. Okay. So it's better to have one person as the administrator and then everybody agree to help them. They're just not responsible. Okay. Understood. Okay. So the court will get an order, will write their order. I hereby grant, Veronica Doe to administer the estate, or to be the executor of the estate of John Doe. And then you will get your letters of administration or letters testamentary, whether it's a will or nothing. And you need to get a certified copy of those. If you do not get a certified copy, you cannot close escrow. So you need a certified copy. And some people get all the way through, and then they have to go back to the court to get their letter certified. Just do it up front. Your lawyer will know to do this. Do it up front, and you'll use your order and your letters to go to the bank, because the bank will then be able to talk to you. If there's a reverse mortgage, they'll be able to talk to you. You've now been appointed. you can start having conversations. This is also separate and apart from actually the sale of real estate. And now you can actually enter into a contract to sell the real estate, because had Veronica Doe sign my listing agreement, she doesn't have power of the property. She can now sign the listing agreement as executor over the estate of John Doe. And that's how the listing agreement will say, Veronica Doe, executor of the estate of John Doe. And then there's a whole separate document that has a representative capacity disclosure. And we'll talk about all those documents, you know, in the next video. But you now have she's now legally able to do the sale.
Okay.
And you need those letters testamentary for a lot of things. And so particularly for the sale, and they have to be certified again by the court. So pre-COVID, it was taking about 6 to 8 weeks to receive your letters. Right. That timeline is a little bit longer now. I'm talking about in LA County. So I have worked and sold properties in Riverside County and San Bernardino County. Their counties run a little bit faster because there's so many probates in LA County. I forget which county it was. I had a pro per, somebody representing themselves, who got their the court granted their petition, and a week later they had their letters. Like, this would never have happened in LA County.
Right.
Never.
San Bernardino, because Riverside is still a little bit bigger than San Bernardino.
Yep.
So I would imagine that it would have been there. Wow, that is impressive.
Yeah, it was impressive, and I was shocked. But I was grateful because we could actually keep the ball moving.
Absolutely.
So most lawyers, so if you hire an attorney, which I recommend, they don't want you to hire a realtor until you have the letters in hand. Okay. They want you to sign the listing agreement after the letters are in hand, but some will permit you to hire a realtor once the court has granted the petition. So after you had the petition, say the matter was heard on September 15th, were granted, and now we're just waiting for the letters to come out from the court. Some will allow you to be retained at that point. Most of the lawyers I work with want to wait until the letters are in hand, which can take several weeks. Key exceptions to this, when I've actually had lawyers say get started now, is if there's a reverse mortgage, because we need to show the reverse mortgage company that no, we don't have the ability to pay off the mortgage. We're using the property, we're going to put the property on the market, and it needs to be actively on the market, because they're going to want to see the listing agreement. They're going to want to see that it's being marketed. I don't know if I said that word right. Forgive me if I didn't. And so they will, they'll work with you. So that is one of the key exceptions I've seen for the lawyers that want you to hold off. If it's under a reverse mortgage, they're like, go.
That makes sense, because there's other timelines that you have to adhere to with the lender after the person passes away. So that makes sense.
Yep. So again, if they signed your listing agreement like before they even were appointed, you may have signed the listing agreement with Veronica, and then she gets to probate court and the wife then wins. Now you have a listing agreement that is not, you can't even use it. It's voidable void because she didn't get appointed. So you need to wait until you actually are dealing with the person, because they also can't sign it in their own capacity. They need to sign it in the capacity as administrator or executor of the estate, and they don't have that authority yet because they haven't been awarded that by the court.
And just so people understand, when you say in their capacity, meaning under their own name, they have to be able to put on there that they're signing on behalf of, because they've been given the authority of the court.
Correct. Correct. So, we're just going to conclude my long discussion at this point.
It's beneficial. No, it's helpful. Definitely.
There's a lot of work that goes into this, as you can see, before you even get to hiring me. Like, we just got through the court hearing. And so it's best to spend the time leading up to the process. Unless you have a realtor that does probate, you can start interviewing people. Have you done probate? Have you worked in this area? That type of thing, and interview realtors, because a lot of them will say, oh, I can sell it. I can sell anything. And there's all these other things that you need to be mindful of. And lawyers feel much more comfortable with people who know what they're doing, because then they're not doing their job and the lawyer's job, and the lawyers can bill for doing the realtor's job. So they are writing their fees down, or they're keeping track of their fees and their billable hours, so because they're going to ask the court for their fees at the end. But you can get extraordinary fees if you now have to do something that's over and beyond an extraordinary than the law job. So you can start working with someone a realtor that doesn't know what they're doing, can cost the estate time and money.
Ooh.
So
another really important point that to mention is you also have to take a look at the will and see if the decedent named a preferred agent, and you have to adhere to their will, no pun intended, but what their intention were, what their wishes were.
Yep. So if they hired, Cousin Lucy to be there, or they specify that Cousin Lucy was going to be their realtor, then you need to talk to Cousin Lucy first. I don't care that you don't like Cousin Lucy. I don't care that Cousin Lucy has sold one property in 15 years. The will says Cousin Lucy is the designated realtor. Now, Cousin Lucy does not want to act. She can waive her responsibility, and then you can move forward. If you are looking for a realtor to put into your will or trust, I'm here. I'd be happy to work with you. And I sell lots of properties, so you don't have to worry about me not knowing what to do. But yes, that is an excellent point. If the will says specifically, name somebody specifically to do the job or to do a job, it doesn't have to be the real estate. It could be, I want this person to, handle the estate sale of all the items in the property. Mm-hmm. You need to do what the document says to do, or you need to ask that person or offer. They need the right of first refusal. If they don't want to do it, that's fine. They don't want to do it. Right. But it needs to be offered, and then it needs to be waived.
Right. So. Wow. All right. One last point. Would you recommend, if that person did waive it, that they put it in writing?
Oh yeah. I'm a lawyer. I want everything in writing.
Right. I
want everything in writing.
As classic as it always happens, you ask the person and they tell you, no, I don't want to deal with it. It's okay, blah, blah. And then all of a sudden, like you're talking about in the situation of an estate sale, and then all of a sudden they see, wait a minute, she had a lot of valuable things. I didn't know she had all of this, or, whatever the case may be. And then they come back and say, I didn't tell you I didn't want to do this. Of course, I wouldn't make you think I didn't. Yeah. So,
yep.
Famous
in writing. Like, it doesn't have to be notarized or any of that. But they need to, even if it's an email, it doesn't have to be a handwritten writing. You need to, offer it to them in email or some other writing, and they need to respond in writing that they, I can't, or I don't want to do this, or I can't do this. And sometimes people just can't do it. Like, you may have named someone as an executor of your will, and by the time you pass away, that person is now caring for their parent or a spouse, and they don't have the ability or the energy. They may have moved out of state, but out of state is not really a problem. There are several clients I've never even met because they live out of state or out of the country, and I sell the real estate for them. Or they may be raising small children that, God help us, we're homeschooling. And so they just may not have the time or energy to do it. So people can waive for a lot of reasons, not necessarily because they're incompetent, but they may not have the capacity at this juncture in their life to handle it.
Understood. Okay. All right. Well, great. Well, this has been wonderful information. Did you have any last closing thoughts, or you feel like we covered enough of it today?
I feel like we hit all the highlights for this half of it. I talk really fast, so if you have any questions, call me or send me an email, message me. I'd be happy to answer. Again, if you need a referral for someone, call me, message me. I'd be happy to answer. But no, we'll pick up at this point, where you would now be able to hire someone, me, to sell the real estate, and then we could talk about, kind of what happens after that process. So nope, I'm good.
Okay, well, great. Well, I mean, as always, these videos are such valuable information. I hope that, everyone who's watching them sees that we're coming from an educational and really a point of caring. We really want to make sure that people understand, because this comes, the purpose of us putting this together comes from a place of us having fielded a lot of these questions And as many of you said, even me, for somebody who has an understanding of real estate and some of the different transactions that go on, there's still a lot even for me to learn. It's a very complicated kind of transaction. And as Erica mentioned, if you have any additional questions, please reach out to her. Please reach out to me. Our contact information is at the end of this video, so don't hesitate to reach out and let us know if you have any questions. And we look forward to seeing what's going to happen in part 2 of this process. Well, enjoy the rest of your day. Let us know if we can help with anything. And it's been another pleasure joining you today.